coming up.
The government has chosen to maybe withhold, hide behind cabinet confidences or lawyer-client privileges.
I think Mr. Motz had said in his comments that the government was, quote, hiding behind cabinet confidence and lawyer-client privilege. I think cabinet confidence is a very entrenched notion in the Westminster style of government. I think it's quite sacrosanct in our tradition. It predates the Charter, and it is...
Thank you, Mr. Chair. I've been sitting on this for quite some time, and we've heard in the opening remarks of Mr. Nakvi this notion, as stated as fact, that this idea of Crown privilege in cabinet confidence is sacrosanct and supersedes the will of Parliament. And I think the references were into his experience as a lawyer, but I would like to put before this committee, and I'm going to ask for your graces in doing this, a compelling argument to the contrary.
This guy's garage.
Let's move forward then, if I could, Chair, to move that we resume the documents motion conversation or discussion, and if possible, could I ask the clerk to read that motion again into the record, please, and then I'd have some comments after that.
I mean, just in the interest of time, Mr. Motz, is that necessary? We've all got it.
Was it read into the record in an in-camera session? Was it read into the record on a
I have no recollection, but
I don't either, and that's why it's important, I think, to have it read into the record publicly.
It'll be in the minutes.
I'm looking at I think the importance of having it read into the record, not for our minute, but for those who will be joining us online, so they know exactly what we're talking about.
But just to be crystal clear, Mr. Chair, so nothing that was discussed that was in camera, that remains in camera. All that she's reading is the text of the motion. Correct? Good. Thank you.
That an order do issue for all security assessments and legal opinions which the government relied upon in determining that A, the threshold of threats to security of Canada as defined by Section 2 of the Canadian Security Intelligence Service Act, required by Section 16 of the Emergencies Act, had been met. B, the thresholds required by paragraphs 3A or B of the Emergencies Act concerning a national emergency had been met. C, the situation could not, open quote, be effectively dealt with under any other law of Canada, closed quote, as required by Section 3 of the Emergencies Act. D, the emergency measures regulations were compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act. And E, the Emergency Economic Measures Order was compliant with the Canadian Charter of Rights and Freedoms, including the analysis relied upon by the Minister of Justice in discharging his responsibilities under Section 4.1 of the Department of Justice Act, provided that F, these documents shall be deposited with the Law Clerk and Parliamentary Council of the Senate, the Law Clerk and Parliamentary Council of the House of Commons, and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order. G, a copy of the documents shall also be deposited with the law clerks and any legal counsel which the committee may appoint in both official languages within 1 month of the adoption of this order, with any proposed redaction of information which, in the government's opinion, could reasonably be expected to compromise national security or to reveal details of an ongoing criminal investigation other than the existence of an investigation. H, the law clerks and any legal counsel which may be appointed by the committee shall promptly thereafter notify the co-chairs whether they are satisfied the requested documents were produced as ordered, and if not, the co-chairs shall be instructed to present forthwith, on behalf of the committee, a report to each House outlining the material facts of the situation. I, the co-chairs shall cause the documents as redacted pursuant to paragraph G to be distributed to the members of the committee and to be published on the committee's website forthwith upon receipt. J, the law clerks and any legal counsel which the committee may appoint shall discuss with the committee at an in-camera meeting to be held within 2 weeks of the documents being distributed pursuant to paragraph I, whether they agree with the redactions proposed by the government pursuant to paragraph G, provided that, upon the request of the government when depositing the documents, the co-chairs shall be instructed to present as soon as possible on behalf of the committee a report to each House recommending that this meeting or any subsequent meeting where the discussion is continued, 1, shall, notwithstanding the order of the Senate adopted on March 3rd, 2022, not be subject to the provisions of paragraphs A to C in the order of the Senate adopted on February 10th, 2022, respecting senators on standing joint committees. 2, shall, notwithstanding the order of the House of Commons adopted on March the 2nd, 2022, not be subject to the provisions of paragraph R of the order of the House of Commons adopted on November 25th, 2021. And 3, may, if the committee decides, be held outside of either House's precincts, but within the National Capital Region at a location acknowledged by the government to be appropriate for the discussion and presentation of highly classified information. And K, the committee may, after hearing from the law clerks and any legal counsel, which the committee may appoint pursuant to paragraph J, accept the proposed redactions or reject some or all of the proposed redactions and request the production of those unredacted documents in the manner to be determined by the committee.
What's become clear through the process over the last, since the 23rd of February, and since we've had witnesses here already and comments that have been made publicly, that the government has chosen to maybe withhold, hide behind cabinet confidences or lawyer-client privileges. So there's no clarity at this stage of any of our witnesses, and I don't anticipate the government being forthcoming with any clarity that would allow us to who asked for the Emergencies Act, what the information that they were dealing with that precipitated them asking for it, and anything the government used to rely on to invoke the Emergencies Act. And we believe, I believe, that the documents that we're asking for in this case, are the information are contained within those documents for us to make an informed decision.
Just to make sure that the record is clear, I think Mr. Motz had said in his comments that the government was, quote, hiding behind cabinet confidence and lawyer-client privilege. I think cabinet confidence is a very entrenched notion in the Westminster style of government. It is to ensure candid cabinet conversations can take place for the betterment and the public interest of all people that reside in this country. I think it's quite sacrosanct in our tradition. It predates the Charter, and it is an important thing to uphold. So it's not an issue of hiding behind something. It's actually an issue of maintaining a principle that allows government to continue. Lawyer-client privilege is equally sacrosanct, and I'll declare my subjectivity on the matter clearly out in the open. There are many other lawyers around this table, but the reason why you have lawyer-client privilege is that so a client can feel confident in having open and very blunt and candid canvassing of all various options with their counsel. Without that kind of secrecy to the communications, you don't have the provision of legal advice that is in the client's best interest, and that is in everyone's best interest in this country. So I just reject the assertion that people are hiding behind these principles. We are trying to uphold them because they're important for our democracy.
Thank you, Mr. Chair. I've been sitting on this for quite some time, and we've heard in the opening remarks of Mr. Nakfi this notion, as stated as fact, that this idea of Crown privilege in cabinet confidence is sacrosanct and supersedes the will of Parliament. And I think the references were into his experience as a lawyer, but I would like to put before this committee, and I'm going to ask for your graces in doing this, a compelling argument to the contrary. And I reference The powers to summon persons, papers, and records has been delegated to standing committees by the Canadian House of Commons under Standing Order 108.1 and by the Senate under Rule 91. Diane Davidson, General Legal Counsel for the House of Commons, has stated, the extensive powers that a parliamentary committee enjoys are not commonly understood and therefore, at times, not properly respected. That this may be due in part to an understatement. Consider for a moment the powers of standing committees as set out in Rule 91 of the Senate Rules and Standing Order 108.1 of the House of Commons. These include the innocuously stated authority to send for persons, papers, and records. No distinctions are made between the different types of documents or categories of witnesses. The very simplicity of the words granted by this authority would appear to belie the strength of the power thereby delegated. And when coupled with the rights of a committee as enjoyed as a constituent part of Parliament, these are very powerful indeed. I want to go a little bit further and reference another important point, which is, again, on Crown privilege, that claims of Crown privilege do not diminish or derogate from the power of the House to require attendance, testimony, or the production of documents. Diane Davidson, again, General Legal Counsel for the House of Commons, has stated that it is important to state that there exists no blanket immunity for the executive branch in making public interest claim against the disclosure of confidential information to a parliamentary committee. The so-called Crown privilege, or more modern designation, public interest immunity, is often invoked by the Crown and more often by ministers in refusing to divulge matters or to produce certain documents in a lawsuit on the grounds that it would be contrary to the public interest to do so. It should be noted that this immunity, and I put emphasis on this next point, has never been formally acknowledged by the House of Commons as inhibiting its investigatory powers. The public interest to be considered and weighed in judicial proceedings are not the same as the public interest to be considered and weighed when evidence is sought by parliamentary purposes. In practice, parliamentary committees have a more readily given consideration to claims of Crown privilege when invoked by a minister in relations to national security and international affairs. However, in the final analysis, the committee remains the final arbiter of such claims. Again, Diane Davidson, General Legal Counsel for the House of Commons. This is a convention. This has not in any way been something that has been given up by the House of Commons as a power. And I think that by framing this in the way in which it has been framed in the opening comments of Mr. Varani, it in fact undermines our power as the Grand Inquisitor of the nation. And we see this time and time again. And it's, you know, there are multiple lists. I heard that he framed it as it being one of the foundational principles of the Westminster system. If he would wish to continue down that road, I have examples from many other jurisdictions where this has been defeated in its very notion from every Westminster system. And I'm happy to state that should he have questions on those matters. But, you know, I'm not clear there's going to be a committee in my time on Parliament that's more important than the one that's before us. And if we don't get to the hearts of the matter in an open, public, and transparent way, one that doesn't at every corner seek to reduce, redact, and retract public inquiry into this, we're going to be back in this committee in no time flat, because that's where we are. And I've stated that time and time again, Mr. Chair, that regardless of what side of the issue Canadians are on, we have a duty as a committee to bring forth the truth and the facts of the matter. The challenge that we have, and I think the imbalance that this committee has, despite I think its very wise constitution of senators and party members, is that only one side has access to the facts. As somebody who supported it, I want to be able to go back to my constituents with the facts of the matter as presented in an evidence-based way that support the decision I made. I'm also prepared, Mr. Chair, that if the facts bear out that a mistake was made, then I think our responsibility as a committee is to provide recommendations back to the House of Commons and the Senate and Parliament that will ensure this doesn't happen again. So, you know, I don't want to allow the conversation around the table to continue to mislead Canadians on the power of this committee, or perhaps underestimate it or understate it in a way that isn't actually true to the jurisprudence of the House of Commons.
This Guy's Garage. Like and subscribe.